tourism minister and the people. Next, this is the asker.
Good afternoon, everyone. Please mute your mics. Thank you.
Carol.
I care for nothing. Even part of violin.
Good afternoon, everyone.
Good afternoon.
Good afternoon, everyone, and thank you so much for joining us. My name is Carol Rose Brown, and I work for the Tourism Enhancement Fund. The Honorable Edmund Bartlett, Minister of Tourism, has kindly agreed to join us this afternoon to introduce this third lecture in the series, Tourism and the Law, the Employer's Duty of Care. The lecture is presented by the Jamaica Center for Tourism Innovation, a division of the Tourism Enhancement Fund, and in association with the Minister. Please allow me to welcome all of you who have joined us, especially members of our own ministry and the members of the Jamaica Hotel and Tourist Association and many other guests. Before further ado, however, please let me invite Minister Bartlett to make his opening remarks. Minister. You are muted, Minister.
Am I now unmuted?
You are now unmuted.
Fantastic. Well, thank you very much, Ms. Brown. And a very pleasant afternoon to everyone who is on the platform and then those of us in Cyberland. I think this topic that we're treating with today is very apropos, especially given the new protocols that are emerging in tourism, and particularly the way that this with COVID and post-COVID configuration is architecturing itself. We are, I think, in a special period when tourism ethics is going to play a bigger role in the way in which service provided and relationship processes are carried out throughout destinations. And so I think it is appropriate that Jamaica should be taking a lead position in starting a sensitization program in this area, and more importantly, to bring our players or key players into a more formal arrangement with tourism and the legal implications of our own interactions. So when you think about tourism, I think it usually evokes images of amazing places, rest and relaxation, new adventures and exciting experiences. Very rarely does the law come to mind, yet tourism and the law are closely interlinked. The tourism and hospitality industry is a complex multi-billion-dollar network of accommodations, restaurants, tourism destinations, attractions, airlines, and other transportation, interacting with each other and vacationers through the provision of goods and services. So this is where I think the law comes into play. Let us look at the industry from the widest perspective. Jamaica is amongst the most sought after vacation destinations in the world, topping major international travel awards every year. Yet, this is not by accident. It is a result of a regulatory framework which the government has put in place for the proper management and development of the sector and its activities. These laws and regulations protect our natural and cultural resources, businesses, investors, and travelers' rights. They also ensure the smooth functioning of this multifaceted industry. They cover, to name a few, planning permissions and building control, occupational health and safety, discrimination and equality, data and customer protection. The Jamaica Tourist Board Act, the Tourism Enhancement Fund Act, and the Travel Agency Regulations Act, among other core legislation, are integral to creating a tourism product that is compliant, safe, secure, and seamless, and delivers the memorable visitor experiences that our marketing campaign promises. Moreover, like most of the tourism-dependent Caribbean, Jamaica's tourism industry is the bread and butter of the nation's economy, providing much-needed employment, foreign exchange, and tax revenue. It is a catalyst for social economic development and bettering the lives of our citizens. Consequently, laws to enhance and protect it are essential. Ensuring the sustainable growth of our tourism industry requires strong and comprehensive laws that foster proper management of the business activities, efficient oversight by government, and equal opportunities for all our citizens. Equally important, however, are the laws that affect the day-to-day operation of hotels, attractions, restaurants, tour companies, convention facilities, and other businesses. For example, restaurants have the legal obligation to ensure that the food they offer to customers are safe to consume. And hotel, clubs, and other businesses must ensure their premises are not a fire hazard to occupants. What about the laws pertaining to sexual harassment, damage or lost luggage, discrimination, data privacy? It is a duty of care that presumes that you, the business operator, will be responsible for ensuring the visitor or clients safe, to make sure that they remain safe from reasonable harm and distress. Industry operators and workers need to know our nation's laws and obligations so that they can prevent lawsuits, fines being imposed, and reputational damage to the company and other national brand, which takes sometimes years to build and only minutes to destroy. We are therefore pleased to be rolling out the third in the lecture series, Tourism and Law. I just want to indicate that when this idea was first born, it was born out of the need for us to fully recognize that tourism is perhaps one of the most litigious industry in the world, and that everybody is very careful about how they move, where they go, and what they do, and that contracts are drafted for almost every aspect of the tourism work. So the collaboration between my ministry's training arm, the Jamaica Center of Tourism Innovation, and the University of the West Indies has been positively received by participants. And I want here to pause to appreciate and recognize Mrs. Folks Abrams for the pioneering work that she did and is doing, in fact, with us in building out not just this relationship, but this entire program that has been going on so well. Employers need to ensure their workers have a sound knowledge of the requirements set out in the Jamaica's common law. This is even more critical as we operate in a fluid COVID-19 pandemic environment. The focus on health, safety, and security are at all-time high. The JCTI, headed by Carl Rose Brown, has been doing a fine job of facilitating the training and certification of the hospitality sector's labor force as part of our commitment to developing Jamaica's human capital. This is critical in maintaining the success and competitiveness of our tourism product, especially as the pandemic forces a tourism reset. In fact, it's only this morning that we spent some time talking about this reset. So this reset requires a shift in mindset as we seek to uncover hidden opportunities in the tourism industry amid the COVID-era economic uncertainty. A skilled and educated industry workforce will be a critical factor in this new arrangement. I'm pleased to share that since starting in 2018, the Jamaica Center for Tourism Innovation has facilitated the certification of some 7,194 persons in categories as follows: certified hospitality educators, certified hospitality instructors, hospitality and tourism management program professionals, certified mixology tutors, certified culinary tutors, certified hospitality analytic tutors, certified culinary evaluators, certified hospitality supervisors, certified culinarians, to include sous chefs and executive chefs, certified bartenders, certified guest service professionals, certified hospitality industry analytic professionals, and we could go on. And I want to add that the work that the JCTI has to do in collaboration with the Human Employment and Resource Training, NSTA, and the Universal Service Fund and the National Restaurants Association and the American Hotel and Lodging Institute are going to be seminal in terms of enabling not just the building out of skill sets that will add value to our human capital, but will enable a level of portability and of course, mobility within the sector. And only yesterday I had discussions with one of our partners who want us to train a number of workers who will go into the Eastern Caribbean and in products that they are creating, because Jamaica is seen as a destination where focus has been on training. And we think that our workers are able to transmit those values to other places, and more importantly, to be able to add to their own value as professionals and earn better salaries. So the JCTI is taking steps to move most of its certification programs online. And the American Hotel Lodging Education Institute is in the process of upgrading its website to accommodate more online presentations. Starting in April, the JCTI will be offering mostly free of charge 4 AHLEI courses outlined as follows: certified hospitality supervisors, certified spa supervisors, customer service goal, certified restaurant server, and serve safe. Further, The JCTI is offering several middle management certification programs to include certified food and beverage executive. They'll have the CFBE designation. Certified hospitality housekeeping executive. They will have the CHHE designation. Certified hospitality trainer, CHT designation, and certified hotel concierge, the CHC designation. In addition, currently, 45 candidates are preparing for their culinary arts certification offered by the American Culinary Foundation, ACF. And their exams are scheduled for late March and early April in 2021. Finally, the first cohort of the Hospitality and Tourism Management Program, the HTMP, were rolled out in our high schools in September of 2018 in concert with the Ministry of Education, Youth and Information, has now completed their course of study. These graduates have a certificate from the AHLEI and an associate degree in customer service and are ready to take up entry-level jobs in tourism. We believe that these young people from all across the country will help to boost the sector's competitiveness in the post-COVID-19 era. JCTI is providing wonderful opportunities to our industry workers, and I'm pleased that all of you can benefit from what I'm sure will be a fruitful and beneficial webinar. Finally, I would like to take this opportunity to express my sincere thanks to the JCTI and the UWI teams, and in particular, our presenter, Ms. Tamika Davis. Enjoy your day. I know it will be fruitful and beneficial, and I look forward to getting the results later on, as no doubt the report from Ms. Brown will be forwarded to me for evaluation. Thank you all very much.
Carol Rose, you're muted.
I'm sorry. I'm sorry. Let me start again. Thank you, Minister, and I promise you'll have your report as requested. Let me spend a few minutes to introduce Ms. Tamika Davis. She's a first-term member of Parliament for Western Hannibal, and she's the first woman to achieve that distinction. She attended Rusies High School and graduated from the University of the West Indies before pursuing law. She's an attorney at law for over 15 years and has done stints as a clerk of the courts for the family court in parishes of St. James, Hannibal, and Westmoreland. She's a practicing commercial attorney for the Montego Bay Airport Limited, as well as the Sangster International, and is highly regarded in her field. We want to thank her for participating this afternoon and doing this lecture, which, as the Minister has indicated, is a really important information piece for our partners, and we are delighted to have her. Ms. Davis, take it away. Ms. Davis, we're not hearing you.
Okay, good afternoon, everyone. Are you now hearing me?
We are hearing you.
Yes.
Excellent.
Thank you.
Please go ahead, Ms. Davis.
Okay, thank you so much. Good afternoon again to especially the Minister of Tourism, Honorable Edmund Bartlett, and to all other persons present. I greet you well. Now, this afternoon, the topic for discussion is really a duty of care. And those are the words that I'm sure will be repeated numerous times throughout this presentation. And the introduction given by the Minister is the perfect segue for what we're about to discuss. Now, to answer the question, what is meant by duty of care, it is first necessary to put it in context. When would this term arise? When would I use it? And normally, this is used in cases of negligence. That is to say, an aggrieved person, someone who has been injured, is desirous of suing for the damages that they have incurred. And so the first question to be asked by the court is whether a duty of care is owed. So that is the background against which the phrase a duty of care arises. So now we can just delve into what this phrase really means. A duty of care. Ms. Brown? Well, the Oxford Dictionary gives us a standard quote. It says it is a legal or moral obligation to avoid negligence, and it means you have to take particular care not to cause physical, economic, or emotional loss to others. And while that standard definition seeks to break it down, again, in the context of the law, it really means that you have to be sure as the person in control of property or persons that no harm arises. So the next logical question is, how will we know if a duty of care is owed? You have to first look at the nature of the relationship to determine whether or not a duty of care is owed. So we can look at everyday examples, and it's around us everywhere. When you enter a supermarket, for instance, the moment you enter the supermarket, the store owner owes you a duty of care, a care to ensure that during your shopping experience, that no harm arises, that the floor is clean and dry, there are no slippages. And we could also look at our taximen, the taxi drivers, and whether or not we speak about taxi drivers. Drivers normally owe a duty of care to passengers.
Be a professional there, but she do everything the most important part of apologizing to the guest and talking to your superior.
Means the attention of your superior.
Right. Then we will do the next one if you have.
Okay, so as I was indicating, there are different everyday examples of the duty of care. And we had looked at the supermarket, the drivers, manufacturers, and so on. Doctors, especially in the midst of this COVID, we consider whether doctors and patients and nurses also have that duty of care, and the answer is readily yes. So by looking at those examples, you can see very easily that the relationship that must exist is one where the person who is seeking this suit has a reliance on the store owner, the driver, or as the case may determine. So there is no limit, there are no exclusions. You have to really always examine whether or not this relationship exists. And common law has determined that for us. Common law is really the number of cases that have come before the courts over a period of time. And by looking at these cases over years and years and years, we can firmly say that these relationships exist in the examples I just gave, for instance. Next slide, Ms. Brown, thank you. Right, so just to recap, we ask in the matter of the negligence suit whether a relationship exists, and if the answer is yes, the next question to be asked is whether the damage that is complained of or the harm, was it reasonably foreseeable? And that again is a term which the courts have assisted in helping us to define. The reasonable man. In the UK, they say the man on the Clapham bus. In Jamaica, for purposes, we say the man in halfway tree. So the test to determine whether or not it is reasonable is our average man. It is not the highly educated, it is not the ones at the bottom of the scale, just the average person on a bus in a halfway tree. Now, if that ordinary person would form the view that it was reasonable, then the judges have determined that that is the test that is to be applied. So we have looked at the negligence claim, we have looked at the relationship, we look to see whether or not it is reasonable, and then we look next to see whether proper guidelines or steps had been taken by the persons. So to help you to better understand, we're going to divide the duty of care into the three most common areas. And the first of which is the occupier's liability. The occupier's liability speaks to an occupier, the owner of a home or a hotel, again, has invited anyone onto their premises. So in your private homes, if you invite me over for dinner, for lunch, as I step through your gate, you immediately owe me a duty. You have to ensure that whilst I'm on your property, no harm comes to me. And that is no foreseeable harm. It means that if you have a walkway, it should be dry. I should not slip and fall. If you have a staircase, it should not be, there should not be any hidden hazards, so to speak. If there's a tree in your yard and there are overhanging branches and I'm under the tree, you have to ensure that no fruit falls, if you can foresee that, and causes any injury. And so it goes on. But in our everyday lives, in our own homes, once we have a visitor or a guest, the duty immediately starts to operate. And so that duty of care is identified, and you have to ensure that your guests are protected. The second, which is closely related, is the vicarious liability. Now, vicarious liability, coming from the occupier's liability, is saying that if, using again that same example, if I'm at your home, you are not there, but you have left a relative in charge, although I'm there to see you. If the relative causes or does anything to cause harm to me, then you can be liable through the concept of vicarious liability. So while you might not be present because of the duty imposed on you, if there is someone who is acting in your stead, you can also be held liable. And thirdly, and this is where we're going to spend most of our time today, is on employer's liability. And logically so, because the employer has a duty of care to the employee. Now, this duty of care is divided for the purposes of this presentation into two parts. Because in the tourism sector, in the industry, not only do we as employers owe a duty of care to the employees, but also to our visitors, our tourists, and which is why it is important that we examine in greater detail the duty that is imposed under this heading. Next slide, Ms. Brown. We're at employer's liability. Okay. Right. We've already looked at the occupier's liability, and again, we'll reiterate, it is a duty that is owed once someone, a guest, is on your property. And I must also add that while common law dictates what happens in Jamaica, we also have what we call the Occupiers Liability Act. So in addition to the common law position, there is an act which really codifies, puts into words in a statute, the very same concept that I just outlined. That is to say, when a guest enters your premises, private or public, the duty is owed immediately. And the risk would be higher depending on the age and the nature of the persons. So for instance, if a child enters my home, there is a higher risk because children will be children. And if they see something shiny that is perhaps a security hazard and they play with it, the law imposes a greater duty on you where children are concerned. And the flip side is older persons. When you have older guests, the law imposes a greater duty on you to ensure that they are safe. We look out for the most vulnerable, the youngest in our society, as well as the eldest in our society. So that is the position on the occupier's liability. Thank you, Ms. Brown. Vicarious liability, again, we would have just discussed. It is while you might not be personally on the property at the time, if it is that you've left an agent in charge, depending on the circumstances surrounding that agency, the law deems that you will also be held accountable if someone is injured on the property. Next slide. All right, so we are at employer's liability, which is where, as I said, this will be our focal point. Right. So the common law has established that there are four main responsibilities as it relates to the employer's liability. The first one is to provide competent staff. First one, providing competent staff. And that is self-explanatory, really. You as the employer have a duty to ensure that the persons within your employ are competent, are qualified, that they know the job, which is why the minister spoke about training earlier. So this is how training becomes relevant. You can't have perhaps a waitress, for instance, who is only familiar with construction work. That would not be a competent person. It would require, if it is that it is going to be a change of occupation, training would be needed, but it cannot be without more that someone who has no training, no skill set is employed and put in a position to act. What that will allow is, in the event that someone is injured as a result of the incompetence of this individual, the law will deem you liable to compensate this person. And so the provision is the need to provide competent staff. Next slide, number 2. The law requires that you have adequate plant and equipment. Now, this speaks to the physical layout that must be observed in our places of employment. That is to say, the physical structure must be safe and that the requisite infrastructure and material needed for the job to be completely and accurately done is provided. This is a necessity. It means that you will want to ensure that your employee is safe. For instance, a fire truck, the fireman who goes out necessarily needs a fire truck, a hazard. He will need to ensure that he has the tools ready. And again, the examples are not closed, but it really comes down to having the right equipment to ensure that when you do your job, you do it safely and accurately. Thirdly, the next slide, I just want to introduce a case without getting too much into the legalese, a relevant case as it relates to what is meant by a safe plant and equipment. In this case, it's an old case, it comes from Barbados, and in that case, the plaintiff, the person who's complaining, was employed as a mechanic, and he was sent to repair a vehicle which was broken down at the airport, and while attempting to repair it, it caught fire. He suffered the burns, and when he attempted to extinguish the fire using a cloth. So clearly, in this instance, as I've said before, he was not properly equipped to deal with the situation, and the court held that the employer was in fact liable. Next slide. All right, safe system of working. Now, the safe system of working is perhaps the most often used in our everyday situations in our court, because the employer must organize a safe system of working, and that means that the training that was spoken of earlier is in place. And not only that, that the setting is also on par, and that our employees have all the requisite materials that would be required to ensure that they perform to the best of their abilities. Within the hotel space, it would normally mean supervision and again training. So this is one way of ensuring that we comply and we are not deemed to be in breach of this duty of care. And finally, I will come back to the case, Ms. Brown. Can you just go to the other slide? Thanks. Effective supervision. Now, it may appear as if they're all related, and it is true, but because of the nature of the cases that have come before the courts, this is how we have found that it is best to detail what the duties are that are to be imposed on the employer. And so again, in the scheme of this presentation, it is deemed absolutely necessary that depending again on the nature of this person's job, that they are supervised. It does not necessarily mean you have a manager who is doing a day-to-day check, but clearly that checks are done periodically to ensure that all the policies of the company are being observed. So having established and looked at the main components of the employer's liability, now see how we can superimpose that on tourism, specifically in the industry, tourism industry. All right, safe place of work, we have that. Next slide. Right, so now that we are armed with all this knowledge about what the duty of care means and how it is to be applied, let us now go and visit it in the context of tourism. Again, there are two main areas. One, the duty of care that would be owed to guests or tourists or visitors, and that which would be owed to the employees. And at this point, really, I could end the presentation because you are now armed with all the information you need to see how it would apply. Now, the duty of care that is owed to the guest is simply having put in place all the components to ensure that when the guest arrives, that he is safe. And to provide this safe environment would mean that all the components we've just outlined are adhered to. It really means the provision of notices, signs, training, and ensuring that the guest is allowed to enjoy all that we have to offer. Because as the minister indicated, it is not simply that one hotel. It's brand Jamaica. And so a guest who had an unfortunate incident at one hotel is not necessarily going to name that one hotel, but will say that this happened in Jamaica. We can't always foresee, and remember we spoke about foreseeability in the earlier stages. We can't always foresee, but clearly at this point, we would have had enough cases to know now what are some of the things to look out for to avoid the pitfalls that we can fall into. And again, it is simply ensuring that their property is safe at all times. So whether it is in the room, in the halls, the treatment by the employees to the guests, when we look at the entire stay of this guest, we have to ensure that this duty of care is not breached, because we have already established that the duty of care is owed. We know this because of the law of occupiers' liability and because of the employer's liability. So there's no escaping it, really. So having established that the duty of care is owed, we have to now ensure that we don't breach it. And these are some of the ways we can ensure that it is done. Now, the duty of care that is owed to employees. Again, this, we have seen a number of cases that have come in our local courts in which employees are alleging that they have been injured on the job. And essentially, the matter to be determined by the court is whether or not the employer had done all it could to foresee the harm and had taken the necessary precautions. For instance, again, I'm going to hop on the waitress. The waitress is in the bar and she's serving, or in the restaurant, and she's serving a meal, and she slides on the floor. Was the floor wet? What are the rules, if any, if a floor is wet? What about the footwear? So essentially, hotel owners are advised at all times to have a handbook outlining specifically to the employee all the policies that must be adhered to. And if this is not in place, then without more, the hotel would be deemed to be in breach of this code. What we have found is that hotel owners often say, well, this person came recommended by Miss Brown, and so we assume that she was trained. We never checked, and we don't know the level of her training, and she does not know our policies. You'll be deemed to be in breach. So advisably, what you would want to do is ensure that every employee understands the risks that are going to be present and how to treat with it. Because in the example I just gave, if the policy is, if the floor is wet, a caution sign is to be erected, or whether there is another member of staff who has a duty to ensure that it is immediately dealt with. Those are the factors that the courts will look at to determine whether or not this duty of care has been breached. Next slide. All right, so now that we've looked at the employer's liability, it is crucial that we look at it in the context of COVID-19. Now, the protocols have been repeated so often that by now I'm sure it is a song to most of us. Social distancing, keep your distance, wash your hand, always wear your mask. So this duty of care is new to us, because before last year, we would not have matters that would treat with this. But it has become our new norm. And it means that this duty of care extends to include how we treat our guests and employees in the midst of this pandemic. It means that we have to go a step further now as employers to ensure that we are adhering to the protocols, to ensure that the environment is safe. The environment is safe for guests and employees alike. It is doubtful whether cases under this heading would succeed. And this is because for a negligence suit to be initiated, you would have to prove that you've been injured or harm has been caused. And I'm speaking as a defense attorney now. And it would, to my mind, it would be very easy for the employer to say, it would be hard pressed for any employee to prove that the protocol was breached at the location. But notwithstanding that, it is still important that all the protocols are observed to lessen the likelihood of such a claim arising. So again, it would address the needs of the tourist as well as the employee alike. For the employee, it means that you would have to outfit them with the relevant tools to enable them to observe the protocols, whether it means the provision of masks, sanitizers, and just the overall layout, depending again on the circumstances of your institution. If it is a BPO, the seating arrangements would have to differ. And at the front desk, reservations, and the examples could go on. But then the duty would extend in the midst of this pandemic to include how we treat our guests and employees alike in the midst of the pandemic. Next slide. Right. So we have looked at the duty of care, what it really means. But I think more importantly, we have to underscore how it is that hotels can limit their liability. Again, it is really just adhering to the 4 core components of employer's liability. And it is really ensuring at all times that the space is safe. And by safe, we have to include now the COVID-19, but certainly the physical structure and its outlay has to be at the forefront of the employee's mind when we consider, of the employer's, I'm sorry, mind in addressing this issue. So training, ongoing training is crucial, and it is the best way to limit liability. Notices, the provision of notices will also assist and will diminish your liability, because clearly, again, we go back to the occupier. If I'm at my private home and I invite you as a guest, I did not tell you that I have Rex in the backyard who comes out to greet you before I can. Then if I had a sign well erected at the front of the yard saying a dog is on the premises, beware, you would have had notice then. Again, this is limited because it wouldn't apply to children, of course, but certainly a notice would limit. And you will see it in most parking spaces. You see the signs every day. It doesn't absolve you altogether, but what it does, it really limits your liability. Park at your own risk. Signs like those really go a long way in helping the courts to determine whether you had taken steps, whether you had foreseen that something could happen, a vehicle could be stolen or damaged, and in anticipation of that, you are alerting the guest, the visitor, the employee to this possibility. It would be deemed as a step that you have taken to limit your own liability. So every reasonable precaution must be taken. And so the way forward. Presently, the Jamaican legislation is limited, or there is a loophole in that, as I explained from the outset, apart from the Occupiers Liability Act, everything is really governed by the common law. But there is in fact an occupational safety and health bill, which was first laid in 2017, which would seek to effectively outline the terms under which employers are to act in relation to employees. So it would not be on a case-by-case basis. What this bill proposes to do is to set out, and I don't know whether we have section 3 here, but section 3 of the proposed bill really captures how the law would want to see employers treat the employees. So it would not so much this duty of care and looking at it as on a case-by-case basis. It would be a matter of following the law and following the steps as outlined in this act to determine whether or not you're liable. So again, I heard the Governor General speaking earlier that this is one of the acts that we intend to pass through the houses very quickly. And this is the only thing that would change all that I have said earlier. It would not change it to the extent that it no longer applies, but certainly to the extent that the Occupational Safety and Health Act is passed, it would mean that employers would have to be guided by the terms of this act. Because clearly that is the loophole that employees face. Speaking on behalf of the employees now, because if we consider a scenario where a receptionist is in her office and above her there is a rickety fan, and when she turns it on, it makes noise and she fears that it will fall and injure her. Until and unless it falls, the employee really has no recourse. But this act would cause her to say to her employer, I feel unsafe and I don't want to wait for it to fall before I can make a claim. This act would actually give employees the opportunity to make a claim without there being any injury. As it is now, there must be injury. You can't make a claim until you have suffered loss in some way. So whether your hand is broken, you've slipped, you had to go to the doctor, whatever the injury is, for all of this to apply, there must be some. So that is the fundamental difference that this occupational act will bring. That's the fundamental difference. But clearly, it is going to help employers as well, because it will outline in a more direct way the policies that they must adhere to, policy statements will be written and will allow persons to more readily be able to conform to the laws to ensure that the matters in the courts are really reduced. And so the duty of care, that is what is meant by duty of care. I hope that you have understood and you are now ready to apply if you have not already applied it. Certainly, it is something that we interface with every day, whether in our everyday lives, the duty of care applies in every aspect of our lives. And I surely hope that after this presentation, you'll be better armed to avoid being dragged before the courts for having breached this duty of care. I thank you so much. Ms. Brown?
Carl Rose Brown, you're muted.
Until she comes, I had. Oh.
So can we, I'm not hearing myself, but I wonder if everybody's hearing me?
Yes, we're hearing you now.
Oh, excellent. Thank you, Ms. Davis. That was certainly an eye-opener for me. It is a very interesting time. I think it's a timely kind of conversation to have. I wonder if there are any questions out there from our audience.
Hi, this is Robin Russell. I have two questions, if
Go ahead, Mr. Russell.
permitted. All right, the first one is, you just frightened me a while ago with the ability of my staff to seek compensation for injury that has not even happened yet. That leaves a door open for, I don't even know where to start with that one. So what you're saying is that if a floor is wet and a staff was to sit the floor, they could say, oh, I'm going to sue them because I could have fallen on the floor. Or, you know, I walked under the roof and I saw a piece of board loose on it, so it could have hit me in my head. Is that the gist of where we're going with this?
Okay, so thank you for your question, Mr. Russell. Remember, that is the position that will be obtained in the Occupational Safety and Health Act, which has not yet been passed. So we are still at the point where it has to be reviewed. I believe it will have to go to a joint select committee, and so we'll have comments. But in its draft legislation, it contemplates that employees, like you said, would not have to wait to be injured. But if they foresee a great, and again, it would be a question of whether it is reasonable or whether it is foreseeable. So it is going to be not a subjective test. So your employee can't without more come and say, oh, I feel as if I'm going to get hurt. We would have to look at the circumstances, and then we perhaps have to have an expert to say whether or not this is actually a reasonable. Reasonableness is always the test. And so I wouldn't worry yet, Mr. Russell. We are some ways off before that law takes effect. And I'm sure before that is done, we would have examined very closely all the implications, and we would have as well asked our stakeholders like yourself to be a part of the discussions before it is finalized. So we are still under the common law.
Okay, thank you very much. And I look forward to being a part of that discussion before it's passed into law, because it could really mean a lot of businesses closing without even knowing why or how. You know, I'm sure it would affect insurances and insurance claims, and then insurance not wanting to insure a property, which could be a snowball effect in that, no hotel can operate without insurance.
Right.
Second part of the question, which I didn't, well, second question I'm asking is like outside contractors, and I will be very specific now to a lot of hotels are doing COVID testing, and it comes through the hotel. So in other words, some hotels will collect payment, some hotels are doing it, but at the end of the day, it is an outside provider certified by the Ministry of Health. What liability does the hotel have with a test going wrong, a report going wrong, just some kind of exposure like that?
Okay, well, you put that in a sense as if it were not likely, but I've actually had two persons already who wanted advice on how to proceed. In one instant, I had a client who called me to say that she was going to travel overseas and she went to a lab, which I will not name, and they returned a positive result. And she was adamant that she hadn't left home and she had not interacted. So she really wanted to challenge this result. So she went to another institution, another medical facility, did the test again, and it was negative. And so she wanted to know whether she could sue the first medical lab because of the stress it had put her under when they told her that she was positive. And she was very certain that she had done nothing to put herself in that category. And the advice I gave her is what I'm going to tell you now. Clearly, when the labs did the test on her, they would have advised her that they can't be responsible for the result, because clearly it is going to be difficult to prove where did the error lie, because I'm sure they're working with kids that they did not prepare themselves, and the results, again, they would not have been able to say that they're liable for. And in most instances, as she had done, she had signed a document to say that she would not hold them responsible for whatever the result was. So it would not, I'd be hard pressed to see how the hotel owner would be responsible in a circumstance like that.
Okay, let's go even further. Let's say they were doing the test, they inserted the swab and it has caused some kind of allergic reaction or really some kind of damage then that is culpable. In other words, you can say the lab technician did something that was wrong, and that is proven, or the report that they sent was wrong, and the person they missed their flight now, and so it's a definite, the lab has said we are wrong, we made a mistake, we've erred. How can the hotel now be held culpable with the lab in because the hotel has collected funds or hotel has recommended this lab?
No, again, it would rest solely with the lab, because they are the one who are admitting liability. The admission in of itself is enough to exclude any liability that would rest with the hotel owners. The difficulty would arise if the lab is saying, oh, we didn't sign exclusionary clause, and we're saying we don't know where or how we got that result. Then perhaps a very ambitious plaintiff could sue the hotel as well as the lab. But again, based on our case law, it is that plaintiff has an uphill task to prove the negligence, because if the lab is going to admit it, if that is the scenario you're giving, then there's no question. If the lab denies it, however, then the suit can be initiated, but again, we don't know that it would in fact succeed.
Thank you.
Thank you, Robin, very much for that question. I have another question though. Remember, we're talking about the duty of care in respect of the preparation of staff for taking these jobs. And I wondered what constitutes the preparation of staff? Is it the distribution of a flyer with information? Is it certification by an accredited body? Does the law describe what it means by an adequately prepared and person? Does it describe what it means by adequate supervision?
Okay, again, we look to case law and we look on a case by case basis to determine on which circumstances would best fit what you're asking, because there are different scenarios, different employers, different employees, but at the very basic level, if you'd have to give me perhaps the post that you think of, but whatever it is, that person must be trained and qualified for the job. We know what that means. We really don't need the court to tell us if this person is qualified for the job. You fit a job description, there's usually a resume or training that you must have completed a certain level of training at the very least. So what we're saying is, if in your department you have a job opening for a tourism consultant per se, and this person must have a bachelor's, and you hire someone straight out of high school, certainly the person would not be qualified. And I could give you numerous examples, but if it is that there is a prerequisite, a set of skills that you want and the person has it, then you would have complied. I can go further and tell you that in a matter I had, the employee indicated on her application form that she had been trained by heart. And as it turns out, she had only done a 2-week course. And I'm not sure now whether she had in fact been certified, but the employer without more took her on. And as it turns out, she was not so trained and she was injured on the job. And the employer, in their defense, said, well, we thought that she was trained, she was properly trained. And so what the court said in that instance was that you have a duty to either do further training or, here's the winner, have a handbook that each employee must say that, listen, even if I have been trained otherwise, I am now, by affixing my signature here, confirming that I have been trained in this regard. So you shift the burden. So it is no longer on the employer, but on the employee. And that is my secret weapon right there.
Indeed, indeed. Just as an aside for all the employers, remember all of you pay an enormous amount of heart tax each month, and you pay
There you go.
yearly. And those resources are part of the promotional material that is presented to potential investors. And those resources are available for hoteliers as well as everybody else in Jamaica as employers. And of course, the JCTI, as the minister kindly noted earlier, exists to help ensure that your staff are properly trained and certified. And of course, all of these are done at huge discounts to ensure that we honor the responsibility of ensuring that training and certification happen. I wonder if there's anyone else who has a question.
Yes, I do.
Please, go ahead.
Ms. Davis, can you clarify, oftentimes when you go to a property, whether it's at the front of the house, guest areas, or in the employee areas, oftentimes you will see the sign, park at your own risk. And you mentioned earlier in terms of the duty of care. So if I am paying to stay at a property and I have my own ride, I park where the hotel advises me to park. I do see the sign that says park at my own risk, but I am paying to stay at the hotel. And God forbid somebody broke into my car and I am being told, see the sign, park at your own risk. What do I do?
Okay, thank you. That is a very often asked question. But as I indicated earlier, it lessens the liability on the owner. It doesn't mean that they're absolved or excluded altogether. So again, you would have to look at the circumstances of your case to see whether the parking lot was perhaps in a dark area, there were no lights, and whether they contributed to something happening to your vehicle. So let us say this parking lot is to the rear of the property. There are no lights, there are no security posts. Then in that instance, the hotel can't be said to have fulfilled its duty. But if they, in addition to the signs, they have gone a step further to provide adequate lighting, a security at the post, it would be for a court to determine whether that was sufficient. And invariably, they side with the hotel owners. I don't know if that is a good thing, depending on which side you sit. But if it can be shown that they took all these steps, which would be a different case where no steps are taken, in which the dark parking lot and far away and so on, it would be a different thing. So I don't think the hotel owner could rely on it in the second scenario where it is in this far place and no protection given. But certainly he could advance it in his defense if it were that in addition to the sign, they had taken steps to ensure that your property was safe.
Thank you, Ms. Davis, for that. Any other question out there in cyber world, cyber land?
I had a question, Carlos.
Dr. Wallace, please.
Right. Yes. So, Tamika, very good presentation. Thank you. I just wondered, how do we stack up compared to our competing destinations, DOMREP, Cuba, Mexico, and even the other Caribbean islands, as far as our occupational laws are? I mean, are we on par? Are we below? Are we more stringent? I mean, from a competitive standpoint, where we're, always looking to have investors looking at us favorably. I just wondered how much room we have to be forceful, or have we been too forceful? Where are we in the scheme of things?
Thank you so much, Dr. Wallace. Like we said, I don't know that it is a good thing that this legislation has been bantering about since 2017, because it was the late Honorable Shahini Robinson who tabled it, and to date we have not gone much further in enacting this legislation. But I can tell you that in the Caribbean, we have about let me see, from my memory, I think we have maybe about 4 or 5 of our neighbors who have enacted this legislation. So like you said, it provides a sort of security for tourists too, because sometimes the average traveler will make checks to see whether or not we have enacted such a legislation, and will be a boost for us. I know, for instance, Trinidad and Tobago has it. The Bahamas, they have a version of it which is not as strict as what we are now proposing. But again, just a cursory glance to any traveler, they will see that some Caribbean countries have already enacted it. But like I said, I'm hopeful that this is something we'll be doing in very short order.
Thank you, Dr. Wallace. Ms. Davis, is there any other question? Well, this has been certainly a very interesting hour, very illuminating. And I believe we have a lot of things to think about. I want to focus, not to distress Robin, but I want to focus on what we can do to prevent ourselves from getting to that point. And the fact is that if we do the right thing, if when we're building, the rules of the construction are followed, if we build proper stairs and make sure signs are available when the floor is wet, then we are more often going to avoid this kind of distress. And it is the same thing we are hoping, that as we proceed to expand our industry, that we ensure that people are properly trained and certified, and that the employers look to HEART and to the Tourism Enhancement Fund to help and to support whatever training and certification you require. We are available. We want to help. We are committed to our industry, and we want to serve you. So, Minister, thank you so much for joining us, sir. Ms. Tamika Davis, it has been wonderful. Thank you. thank you, all of you in the audience, for having agreed to spend an hour with us this afternoon. We are very delighted that you were able to make it. Please stay in touch. And of course, if you have any questions, send it through to ourselves and we'll pass it on to Ms. Davis for her comment. Again, thank you all very much. We really, really appreciate you having spent an hour with us. Have a good afternoon.
Thank you.
Thank you.
Okay. No, end meeting, end. Yes.